Civil Code of the Philippines, Donations, Chapter 2, Persons who may give or receive a donation. Article 735, all persons who may contract and dispose of their property may make a donation. Article 736, guardians and trustees cannot donate the property entrusted to them. Article 737, the donor's capacity shall be determined as of the time of the making of the donation. Article 738, all those who are not especially disqualified by law, therefore may accept donation. Article 739, the following donations shall be void. 1. Those made between persons who were guilty of adultery or concubinage at the time of the donation. 2. Those made between persons found guilty of the same criminal offense in consideration thereof. 3. Those made to a public officer or to his wife, descendants or ascendants by reason of his office. In the case referred to in the number 1, the action for the declarative of nullity may be brought by the spouse of the donor or donee, and the guilt of the donor and the donee may be proved by preponderance of evidence in the same action. Article 740. Incapacity to succeed by will shall be applicable to donation inter vivos. Article 741. Minors and others who cannot enter into a contract may become donees, but acceptance shall be done through their parents or legal representative. Article 742. Donations made to conceive and unborn children may be accepted by those persons who would legally represent them if they were already born. Article 743. Donations made to incapacitated persons shall be void, though simulated under the guise of another contract or through a person who is interposed. Article 744. Donations of the same thing to two or more different donees shall be governed by the provisions concerning the sale of the same thing to two or more different persons. Article 745. The donee must accept the donation personally and through an authorized person with a special power for the purpose, or with a general and sufficient power. Otherwise, the donation shall be void. Article 746. Acceptance must be made during the lifetime of the donor and of the donee. Again, acceptance must be made during the lifetime of the donor and of the donee. Article 747. Persons who accept donations in representation of others who may not do so by themselves shall be obliged to make the notification and notation of which Article 749 speaks. Article 748. The donation of a movable may be made orally or in writing. An oral donation requires the simultaneous delivery of the thing and of the document representing the right donated. If the value of the personal property donated exceeds 5,000 pesos, the donation and the acceptance shall be made in writing. Otherwise, the donation shall be void. Article 749. In order that the donation of an immovable may be valid, it must be made in a public document specifying therein the property donated and the value of the charges which the donee must satisfy. The acceptance may be made in the same deed of donation or in a separate public document, but it shall not take effect unless it is done during the lifetime of the donor. If the acceptance is made in a separate instrument, the donor shall be notified thereof in an authentic form, and these steps shall be noted in both instruments. Chapter 3. Effect of donation and limitations thereon. Article 750. The donation may comprehend all the present property of the donor or part thereof, provided he reserves in full ownership or in usufruct sufficient means for the support of himself and of all relatives who at the time of the acceptance of the donations are by law entitled to be supported by the donor. Without such reservation, the donation shall be reduced on petition of any person affected. Article 751. Donations cannot comprehend future property. By future property is understood anything which the donor cannot dispose of at the time of the donation. Article 752. The provisions of 750, notwithstanding, no person may give or receive by way of donation more than he may give or receive by will. The donation shall be in officious in all that it may exceed this limitation. Article 753. When a donation is made to several persons jointly, it is understood to be in equal shares, and there shall be no right of accretion among them, unless the donor has otherwise provided. The preceding paragraph shall not be applicable to donations made to the husband and wife jointly, between whom there shall be a right of accretion, if the contrary has not been provided by the donor. Article 754. The donee is subrogated to all the rights and actions which, in case of eviction, would pertain to the donor. The latter, on the other hand, is not obliged to warrant the things donated, save when the donation is onerous, in which case the donor shall be liable for eviction to the concurrence of the burden. The donor shall also be liable for eviction or hidden defects in case of bad faith on his part. Article 755. The right to dispose of some of the things donated, or of some amount which shall be charged thereon, may be reserved by the donor. But, if he should die without having made use of this right, the property or amount reserved shall belong to the donee. Article 756. The ownership of property may also be donated to one person and the usufruct to another or others, provided all the donees are living at the time of the donation. Article 757. Reversion may be validly established in favor of only the donor for any case and circumstances, but not in favor of other persons, unless they are all living at the time of the donation. Any reversion stipulated by the donor in favor of the third person in violation of what is provided in the preceding paragraph shall be void, but shall not nullify the donation. Article 758. When the donation imposes upon the donee the obligation to pay the debts of the donor, if the clause does not contain any declaration to the contrary, the former is understood to be liable to pay only the debts which appear to have been previously contracted. In no case shall the donee be responsible for the debts exceeding the value of the property donated, unless a contrary intention clearly appears. Article 759. There being no stipulation regarding the payment of debts, the donee shall be responsible therefore only when the donation has been made in fraud of creditors. The donation is always presumed to be in fraud of creditors when at the time thereof the donor did not reserve sufficient property to pay his debts prior to the donation. Chapter 4. Revocation and Reduction of Donation. Article 760. Every donation inter vivos made by a person having no children or descendants, legitimate or legitimated by subsequent marriage, or illegitimate, may revoke or reduce as provided in the next article by the happening of any these events. 1. If the donor, after the donation, should have legitimate or legitimated or illegitimate children, even though they be posthumous. Article 2. If the child of the donor, whom the latter believed to be dead when he made the donation, should turn out to be living. 3. If the donor should subsequently adopt a minor child. Article 761. In the cases referred to in the preceding article, the donation shall be revoked or reduced insofar as it exceed the portion that may be freely disposed of by will, taking into account the whole estate of the donor at the time of the birth, appearance or adoption of a child. Article 762. Upon the revocation and reduction of the donation by the birth, appearance, or adoption of a child, the property affected shall be returned, or its value if the donee has sold the same. If the property is mortgaged, the donor may redeem the mortgage by paying the amount guaranteed with the right to recover the same from the donee. When the property cannot be returned, it shall be estimated at what it was worth at the time of the donation. Article 763. The action for revocation or reduction on the grounds set forth in Article 760 shall prescribe after 4 years from the birth of the first child, or from his legitimation, recognition, or adoption, or from the judicial declaration of filiation, or from the time information was received regarding the existence of the child believed dead. This action cannot be renounced and is terminated upon the death of the donor to his legitimate and illegitimate children and descendants. Article 764. The donation shall be revoked at the instance of the donor when the donee fails to comply with any of the conditions which the former imposed upon the latter. In this case, the property donated shall be returned to the donor. The alienations made by the donee and the mortgages imposed thereon by him being void, with the limitations established with regard to third persons by the mortgage law and the land registration law. This action shall prescribe after 4 years from the non-compliance with the condition, may be transmitted to the heirs of the donor, and may be exercised against the donee's heirs. Article 765. The donation may also be revoked at the instance of the donor by reason of ingratitude in the following cases. 1. If the donee should commit some offense against the person, the honor and the property of the donor, or of his wife or children under his parental authority. 2. If the donee imputes to the donor any criminal offense or any act involving moral turpitude, even though he should prove it, unless the crime or the act has been committed against the donee himself, his wife, or children under his authority. 3. If he unduly refuses him support when the donee is legally or morally bound to give support to the donor. Article 766. Although the donation is revoked on account of ingratitude, nevertheless, the alienations and mortgages affected before the notations of the complaint for revocation in the registries of property shall subsist. Later ones shall be void. Article 767. In the case referred to in the first paragraph of the preceding article, the donor shall have the right to demand from the donee the value of the property alienated, which he cannot recover from third persons, or the sum for which the same has been mortgaged. The value of the said property shall be fixed as of the time of the donation. Article 768. When the donation is revoked for any of the causes stated in Article 760 or by reason of ingratitude or when it is reduced because it is inofficious, the donee shall not return the fruits except from the filing of the complaint. If the revocation is based upon non-compliance with any of the conditions imposed in the donation, the donee shall return not only the property but also the fruits thereof, which he may have received after having failed to fulfill the condition. Article 769. The action granted to the donor by reason of ingratitude cannot be renounced in advance. This action prescribes within 1 year to be counted from the time the donor had knowledge of the fact and it was possible for him to bring the action. Article 770. This action shall not be transmitted to the heirs of the donor if the latter did not institute the same, although he could have done so, and even if he should die before the expiration of 1 year. Neither can this action be brought against the heir of the donee unless, upon the latter's death, the complaint has been filed. Article 771. Donations which, in accordance with the provisions of Article 752, are inofficious, bearing in mind the estimated net value of the donor's property at the time of his death, shall be reduced with regard to the excess, but this reduction shall not prevent the donations from taking effect during the life of the donor, nor shall it bar the donee from appropriating the fruits. For the reduction of donations, the provisions of this chapter and of Article 911 and 912 of this code shall govern. Article 772. Only those who at the time of the donor's death have the right to the legitime and their heirs and successors in interest may ask for the reduction of the inofficious donations. Those referred to in the preceding paragraph cannot renounce their right during the lifetime of the donor, either by express declaration or by consenting to the donation. The donees, devisees, and legatees who are not entitled to the legitime and the creditors of the deceased can neither ask for the reduction nor avail themselves thereof. Article 773. If there being two or more donations, the disposable portion is not sufficient to cover all of them. Those of the more recent dates shall be suppressed or reduced with regard to the excess.